We should have Mr. Butler.
Good morning, Your Honors.
Good morning, Mr. Butler.
How are you?
Very good. I could see you, sir. Excellent. Good morning. All right, Mr. Butler, you are first the case on the docket. And as I indicated before, you do have 20 minutes to make your presentation, and you could reserve up to 5 minutes for rebuttal. So how much time do you wish to reserve for rebuttal before you proceed with your argument?
Your Honor, I may not need that much, but I'll reserve 5 minutes. Thank you.
Very good. Thank you, sir. Whenever you're ready, the court is ready, sir.
May it please the court. I'm Thomas Butler. I represent the appellant Amari Gray. This appeal, as you see, concerns a sentencing issue. You raised the issue of the trial court not sentencing Mr. Gray to a youthful offender sentence. And as you see we quoted the trial court who stated that, okay, I stayed in juvenile a long time. I stayed there for extra rotation, which most judges don't do. And your mom's right, it's a frustrating process, but I followed the law. I always told every juvenile down there, you go from 0 to 60 when you go, in 1 second when you go become an adult. And it's a frustrating process. And the right place to address that would be in the legislature, not here, and I don't deal with that. You are one of the younger ones, or the youngest rather, and some of your crimes were committed as a youth. That being said, however, the conspiracy statute is set up to punish the organization and those involved in it. And Your Honors, we arguing that this case is similar to DeSantis versus State. And
Mr.
also,
Butler, can I interrupt you, sir? And I see that this is what you're alleging in your brief.
yes,
Let's start off with the premise. As you know, our standard of review at this point in time is an abuse of discretion. You'd agree with that, Mr. Butler, correct?
no, Your Honor, I believe that this would be a de novo review based on the Little case, because the court, in rejecting a youthful offender sentence based on those reasons, would be a de novo review under the Little case. Little versus State.
Is it your position that, because when you were quoting what the circuit court said, but then he also went on to say that he said, I don't think the maximum is appropriate, and I don't think that you should be sentenced as much as your co-defendants given your age. Didn't he also say, but however, I think that you need to have time is appropriate? This was his view. And then at that point, he sentenced him to a prison sentence and rejecting the youthful offender sentence. So having said all that, I think your position is that, wait a minute, the judge was under the misimpression that he cannot deviate from the statute and to give a youthful offender sentence given the statements that you have quoted. Is that your position?
Yes, Your Honor.
All right. Well, how do you then, how do you respond to the second part of his statement where he says, but based on this, in my view, I still think it's appropriate for me to give you a prison sentence? That doesn't lend itself to the idea that he thought he had to give him a prison sentence.
Well, I believe he outright rejected, based on those comments, outright rejected the youthful offender sentence, believing that he had to punish under the conspiracy statute, and also for them to go to the legislature.
Okay.
He just outright, sorry, I don't want to interrupt you.
Oh, no, you're fine, Mr. Bell, because when he was responding to the thing in juvenile court, I think it was the defendant's mother was present, didn't she? And there was a big colloquy between her and him, because it appears that her son or been in and out of the system, and she was expressing frustration with the system. And wasn't that almost like in response to that? And he was just wanting to say that he stayed in juvenile for a long time. He understands the system. And with that, can't you also come to a conclusion that because he stayed in juvenile, he's aware of the statute, he's aware of the youthful offender statute as well, that in essence, by his statements, that he's rejecting the right to sentence him to a youthful offender? How do you respond to that?
Well, the state did make a context argument in the brief, and upon further review, my client's mother did testify at the sentencing hearing, and then after that, there was a little argument by counsel, and then my client gave an allocution, So then in response to the allocution, the judge made those comments and then referred to my client's mother as well. So the state did argue in the brief that it was in response to the mother, but not actually, because it was in response to the allocution and with slight reference to the mother's testimony.
All right, sir. Thank you.
Thank you. If nobody has any other questions, I'll reserve my time for rebuttal.
Very good. So you have your 5 minutes for rebuttal, sir.
Thank you.
Let me pause the time here. All right. And Ms. Heim, you may proceed, ma'am.
Good morning, Your Honors and Counsel. May it please the Court. My name is Allison Heim. I represent the state of Florida as the appellee in this case. First of all, it's important to note that none of the issues raised on appeal were raised in the trial court. There's fundamental error is how it should be reviewed, and fundamental error in this context is a judge's refusal to consider a legislatively authorized sentence, and appellant has failed to establish that that's what occurred here. The comments regarding the legislature and the juvenile court, like you said, Judge Kuzam, that was in direct reference to the mother's statements. The judge even said, "Your mom is right." It's very frustrating for judges in a juvenile court because we are legislatively limited. And so the place to address juvenile court limitations is in the legislature, but there's no indication that the judge had any notion or belief that he was legislatively limited in sentencing in this case. That those statements were followed up by the judge kind of weighing the need for rehabilitation for the youthful offender by saying, "You are youthful. A lot of your predicate crimes were committed as a youth." But also, this type of crime and this nature and then the circumstances of your crime do need punishment. So weighing the rehabilitation and punishment interests, in your case, the judge exercised his discretion in saying, in your case, I don't think the 30 years maximum is appropriate for you in your circumstances. And it's important to note too that as the mother stated during the sentencing hearing, that appellant had been in and out of the judge's courtroom, that particular judge's courtroom in juvenile court, for 7 years. So the judge is very familiar with appellant's criminal history. He's also familiar with the facts underlying the conspiracy conviction in this case because he presided over the trial. So with all of that background knowledge that the judge has about appellant's circumstances, he exercised his discretion properly in saying 30 years is the maximum. That's not appropriate for you, but time is appropriate. So your request for boot camp essentially is denied because time is appropriate. And more than 6 years is appropriate, which is the maximum under the youthful offender statute, because 18 years is appropriate. There's nothing in the record at all that shows that the judge had any express predetermined policy to not even consider a youthful offender statute sentencing in this case. There's nothing that shows the judge thought that he was unable to consider that. Instead, the record shows that the judge did consider appellant's particular circumstances. So there's no error in here at all. The judge properly exercised his discretion. So if the panel doesn't have any questions, the state will rely on its brief, and we request that you affirm.
Very good. Thank you, Ms. Heim. I appreciate it. All right, Mr. Butler, actually, you do have your full 5 minutes for rebuttal if you need that.
Thank you. I'll adopt the brief, and if there's any other questions, I'd be happy to answer. Otherwise, I'll rest. I'll ask the court to reverse and remand for sentencing in front of a different judge.
Very good. Thank you, Mr. Butler. Thank you, Ms. Heim. I think at this point that I'm going to ask you then to leave our virtual courtroom, and then we'll go ahead and call the next case. Thank you both.
Thank you.
All right.